the law is sort of an act of codifying various kinds of relationships in society. And as society changes, the law changes to reflect different attitudes about relationships. In American society, physicians have had a long, long relationship to money and power. And what you are in the middle of right now is a very aggressive effort on the part of the law, because of issues of cost and quality, which you've heard about for a long time now, to redefine the relationship between physicians on one hand and money and power on the other. And that's essentially what you are living through as the medical profession. There have been other times, obviously, in the history of the medical profession when the law has redefined relationships in all kinds of ways. And this is not a process that's just about the Affordable Care Act or about health reform here in Massachusetts. This has been going on now for about 40 years in American law. And it has emanated in a variety, manifested itself in a variety of ways. And a lot of the legal structures that physicians, when they were at the height of their power, were able to essentially erect in the law in order to shield themselves from certain kinds of consequences have fallen away. And so now we see a whole new series of legal relationships arising, and you are in many ways the transformational generation of physicians going through this. The issue that gets a lot of attention is antitrust. This is, I think, when I'm asked about this, the most common question that arises. So there is a fundamental tension here in antitrust law. Antitrust law is obviously designed to promote competition and to prohibit anti-competitive activities. So you all know that as the kind of thing that even if you're not a lawyer or somewhere in a civics course or a history course, you read that this is the purpose of antitrust law. The fundamental tension that we're going through now as a nation, I think, is that for quality and efficiency and cost control purposes, long-term quality, efficiency, and cost control purposes, the pressure is to consolidate, 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 to move practice toward some measure of affiliation with a larger purposed entity. So you may not be forming your own ACOs, you may be joining in a venture, some sort of a joint venture that together takes on the attributes of what we are calling now accountable care. And so size really matters. The paradox is that, of course, as size grows, so does market power. And the fundamental mission of antitrust law is to control market power, to make sure that players in the marketplace do not get so big as to exercise tremendous market power over pricing and output. And from where I sit as a health lawyer, when I'm sitting in a discussion with my friends who are pure antitrust lawyers, they are just aghast. They are aghast at the problems in antitrust as it applies to healthcare. And of course, I'm equally aghast that the nuances of healthcare have taken so long to wash over antitrust law. So the battle that's going on now, if battle's the right word, the struggle on the part of federal regulators and state regulators is to figure out, okay, if the federal law that we just wrote really pushes on consolidation and market power in order to get to a quality and efficiency output point, then how are we, the antitrust regulators, going to respond to this? At what point do we put the brakes on and say, well, wait a minute, now it's too big, it's too powerful a player in the market, it's got too much elbow room, it has essentially too much power to control pricing and output. And finding that sweet spot has always been the problem, and we've struggled through landmark litigation around this issue. We have struggled through decades of the Federal Trade Commission and the Justice Department trying to figure out, what to allow, what to bar, and we are sort of engaged once again in this epic struggle. The message to leave you with is that practice formation happens all the time. Medicine is dynamic. People are forming new products in the marketplace all the time. The law is pushing you to act in a joint venture way. The law has eased up on some of the restrictions to joint ventures. The law is struggling with where to set the line on some of these joint ventures because it doesn't even really know yet. But you can see that the law is very much now sort of working toward this realignment. And you know, your next steps will obviously, if you are moving in this direction, will involve direct legal consultation.